In 1951, a public school in Topeka, a capital city of the US state of Kansas, refused to enroll the daughter of local black resident Oliver Brown. This school was closest to the residence of Oliver Brown, but instead he had to enroll his daughter to a segregated school which was farther away from their house, requiring his daughter to ride a segregated bus to the school. School was supposed to refuse enrollment to his daughter as Jim Crow laws were enforced in US, which mandated racial segregation in all public facilities in the states of the former Confederate States of America. This incident compelled the African American Oliver Brown to knock the doors of judiciary for protection of their equal rights guaranteed under the 14th Amendment. Thereby, court gave landmark judgment in the case of Brown versus Board of Education, which declared segregation in public school unconstitutional. Hence, justice prevailed. Likewise, in 1955, a 15-year-old African-American girl named Claudette Colvin was arrested in Montgomery, which is a capital city of the US state of Alabama, for refusing to give up her seat to a white woman on a public bus. Claudette Colvin was supposed to give up her seat to a white woman because of Jim Crow laws. After 9 months of this incident, another woman named Rosa Parks refused to give up her seat to a white woman. Once again, these incidents compelled the African American to knock the doors of judiciary for protection of their equal rights guaranteed under the 14th Amendment. Thereupon, court gave landmark judgment in the case of Broder versus Gale, which declared segregation in public bus unconstitutional. Hence, justice prevailed. The civil rights movement in US that was started by common people like Oliver Brown, Claudette Colvin, Rosa Parks was materialized by impartial judiciary who had a firm conviction in protecting the rights of citizens as enshrined in the Constitution. This is the importance of judiciary in a state where tyranny is a norm. Therefore, common man has to take refuge behind courts for demanding justice. The conscience of these African Americans impelled them to stand for their right of equal treatment, so much so that former President Barack Obama, in his famous speech at Edmund Pettus Bridge, said that because of those African American people, he became the president of USA. President Obama was spot on. As a struggle of these people, 13th Amendment was passed that abolished the 246 years of slavery and 89 years of segregation. It was because of these people that President Abraham Lincoln signed Emancipation Proclamation. It was because of these people that Abraham Lincoln delivered his famous Gettysburg Address and gave historic definition of democracy, that is, government of the people, by the people, for the people. The role of judiciary is paramount in every democratic country because it gives confidence to the citizens to demand their just rights, which compels lawmakers to subscribe to their demands. This was the story of 20th century judiciary of USA, and in the same century, judiciary of Pakistan played in the hands of the most powerful institution, be it a Chief Justice Munir, who legalized the coup d'etat of dictator and usurper Ayub Khan, or be it a Chief Justice Naseem Shah, who himself confessed that judges are not brave enough to confront dictators. Hence, judges prefer to toe the line of dictators so that they can save their both life and job. Since the inception of Pakistan, judiciary has always led the nation down by siding with oppressor at every important juncture. Now, it is important to mention the great judges of Pakistan like Justice Durab Patel and his ilk, who never sold their soul to dictators. Chief Justice Munir once said that if he had not allowed Ayub Khan to rule this country, then army would have overridden the orders of court. Hence, Ayub Khan would have ruled the country willy-nilly. Now, it is evident that Chief Justice Munir lacked judicial courage, which is more important than producing great judgments. Had Chief Justice Marshall lacked judicial courage, then he wouldn't be able to give historic judgment in Marbury versus Madison case. Former Chief Justices of Pakistan, Muneer and Cornelius, were brilliant legal minds, but were also active and unapologetic collaborators of the Ayub and Yahya military dictatorships. Justice Waqar Seth and Justice Shahid Karim gave the reasoning of why they meted out death sentence to Musharraf is because it is an attempt by judges to rectify history by removing the judicial shame of legitimizing past military dictatorships. In such treason cases, judicial reasoning is relevant but always subordinate to judicial courage. But unfortunately, their role couldn't save Pakistan from the tyranny of oppressors. Even today, there is no silver lining of justice being dispensed from court. Rather, we hear trivial populist remarks. This demagoguery by Pakistani judges reached its culmination during the tenure of Saqib Nisar, who followed the footsteps of Iftikhar Ch. The onus of political instability in the country lies with judiciary because when Anwar Zaheer Jamali was Chief Justice of Supreme Court, he said during the premiership of Nawaz Sharif that there is no democracy in the country, rather it is a monarchy. Therefore, people must revolt against it. Now this shows the partiality of judges that goes against his code of conduct. During Anwar Zaheer Jamali's tenure, Musharraf ran away. He approved Panama case despite Registrar Office rejected the Panama case twice. How is this possible that on one hand you are rejecting Panama petition twice and then suddenly you accept the petition? The answer is political engineering, and it was also confessed by former Chief Justice Asif Saeed Khosa that accountability going on in the country is lopsided. Even Imran Khan confessed that Justice Asif Saeed Khosa had commanded him to file petition in Supreme Court so that they can oust Nawaz Sharif. No other person was put to trial under Panama except Nawaz Sharif. Justice Farrukh Irfan's name was in Panama Papers, but he did not get the same punishment as it was inflicted upon Nawaz Sharif. Former Supreme Court Judge Ijaz Chaudhry, in an interview to Suhail Wadaich, said that Javed Hashmi foretold that Nawaz Sharif will be ousted by Supreme Court, and his prediction came out to be true as Nawaz Sharif was disqualified by Supreme Court. Further, Justice Ijaz Chaudhry said that there are many cases of Supreme Court that public never accepted, like sentencing of Zulfiqar Ali Bhutto, so the Panama case is also not accepted by public, he said. Justice Ijaz Chaudhry further said the reason Saqib Nisar and Asif Saeed Khosa held the grudge against Nawaz Sharif is because President Rafiq Tarar did not promote them as permanent judge and Nawaz Sharif was Prime Minister at that time. Now you see, this is how the judges give verdict. Do you remember that when Musharraf trapped Nawaz Sharif in hijacking case, thereby Supreme Court imposed life sentence on Nawaz Sharif, but later Nawaz Sharif was allowed to go to exile, and no one questions that why Supreme Court imprisoned him in the first place and then let him go. The pertinent question to ask now is that whether the verdict of 28 July 2017 on Panama Papers made Pakistan ahead or behind. Obviously, Pakistan took the nosedive because GDP size in 2018 was $315 billion and now in 2020 it is $264 billion. GDP growth size in 2017 was 5.8% and now it is minus 0.4%. Exports in 2018 were $24.8 billion and now they are $22.5 billion. The circular debt in 2017 was 1,026 billion rupees and now it is 2,200 billion rupees. Facts don't lie. Nawaz Sharif told the reason of his ouster in 23 May 2018 press conference, where he said that his actual crime was to change Pakistan's foreign policy in the best interest of Pakistan, whereby we would have got rid of non-state actors because of whom Pakistan is labelled as a terrorist state. He said his second crime was to file a reference against Musharraf treason. He asked few questions that cannot be answered by any court, and that were why Liaquat Ali Khan, why Zulfiqar Ali Bhutto, why Benazir Bhutto were murdered, why they were not allowed to complete their tenure, why judges always help dictators, why general rule this country, why twice rejected application of Panama suddenly fixed for hearing. Had intelligence agencies ever been part of these type of JITs? Had Supreme Court ever given different verdict in the same case? Had Supreme Court ever monitored the proceedings of JIT? Why he was disqualified on the basis of Ikama while petitioner never appealed against it in his petition? Had Supreme Court ever taken refuge behind Black Law Dictionary while Pakistan has its own well-defined law? Had it ever happened that when those two judges who had already given a verdict against me should be in a part of 5-member bench? Had it ever happened in the history of Supreme Court that Supreme Court judge is appointed to monitor the lower NAP court? And the answer to these questions were given by Judge Arshad Malik's leaked video, where he confessed that he was blackmailed to give verdict against Nawaz Sharif. You see, it is ridiculous to disqualify someone for lifetime, and it is against the spirit of law to not allow the voter to choose his or her ruler. After all, it is Pakistan where anything is possible, as we have discussed that Nawaz Sharif was given life sentence by Supreme Court and later allowed to go to exile. Tenure of Saqib Nisar was worst in the contemporary history of Pakistan. Every chief minister attended the court of Saqib Nisar. He disqualified Talal Chaudhry, Danial Aziz and Nihal Hashmi on contempt of court. Lately, Prime Minister Yusuf Raza Gilani was also disqualified on contempt of court. The judge who proceeds contempt of court case is an intellectual dwarf, because it is absolutely moronic that during contempt of court proceedings, judge is himself a victim, a prosecutor and a judge. Besides, the trial in contempt of court starts from the presumption of guilt rather from presumption of innocence. This goes against the spirit of fair trial, and it is apt to recall what Justice Black wrote in the Green case, that the defendant charged with criminal contempt is thus denied an indispensable element, the due process of law. In a democracy, freedom of speech must prevail over contempt of court. Mahatma Gandhi once said, "Freedom is not worth having if it does not include the freedom to make mistakes." This contempt of court proceedings is a medieval idea, and we find its origin in England. In 1631, a person after his conviction for felony threw a brick at Chief Justice Richardson. He was indicted, his right hand was cut off, and then he was immediately hanged in the presence of the court. In 1634, a similar offence was committed by Williamson as he threw a stone towards the judge on the bench. Thereupon he was indicted, his right hand was ordered to be cut off, and the hand was fixed at the entrance of the gate, where it continued to be for some years. Henry V of England, who won the 100 Years' War against France, was convicted in the law of contempt when he was Prince of Wales. One of his servants was arrested for committing a felony. The prince appeared enraged. Chief Justice Gascoigne ruled that the laws of the land must be met. The prince was sentenced for contempt and committed to King's Bench prison. This episode has been eloquently dealt with by Shakespeare in Henry V, Part 2, Act 5, Scene 2. In the year 1906, the House of Commons passed the resolution that the jurisdiction of judges in dealing with contempt of court was practically arbitrary and unlimited, and called for the action of Parliament with a view to its definition and limitation. The law of contempt did not and cannot stop criticism of the courts. Even Quaid-e-Azam Muhammad Ali Jinnah and Mahatma Gandhi, both barristers, made comments about the highest tribunals. In February 1925, Sir Hari Singh Grover moved in the Legislative Assembly a resolution for abolishing the jurisdiction of the Privy Council and for the establishment of the Supreme Court in India. Mr. Jinnah supported him and observed, "I have no hesitation in saying that the Privy Council has on several occasions murdered the Hindu law and slaughtered Mohammedan law." In 1946, the British Cabinet Mission announced its plan for the transfer of power. One of the terms was the grouping of Assam and Bengal. The Congress opposed it. The Cabinet Mission suggested that the opinion of the Federal Court may be sought, to which Mr. Gandhi observed, "The Federal Court is the creation of the British, therefore it's a packed court." In 1993, the Supreme Court reinstated Mian Muhammad Nawaz Sharif as Prime Minister, and Benazir Bhutto commented that Chamak had been at work, but no action was taken against her. Arundhati Roy, the celebrated writer, in an affidavit before the Supreme Court, said, "It indicates a disquieting inclination on the part of court to silence criticism and muzzle dissent, to harass and intimidate those who disagree with it." she was held guilty of contempt of court. She refused to apologize. She had stated that she did not believe in the contempt of court. Every institution, in her perception, must earn respect and they cannot demand it. The Supreme Court of Pakistan has heard important cases of contempt proceedings against 5 Prime Ministers: Zulfiqar Ali Bhutto, Mian Mohammad Nawaz Sharif, Benazir Bhutto, Sayyid Yusuf Raza Gilani, and Raja Parvez Ashraf. In India, the proceedings for contempt were instituted against Prime Minister Pandit Jawaharlal Nehru in the High Court of Madras, which was rejected in limine. But now England courts have evolved. They don't take contempt proceedings seriously. Lately, during the Brexit, Daily Mail said that these judges are enemies of people. No contempt of court proceedings was initiated. Saqib Nisar used to address Rao Anwar with respect in the court, but he humiliated all the public representatives of people of the Pakistan. For instance, he threw the file of Khwaja Sadr Fiq and humiliated him verbally. Saqib Nisar never stopped Rao Anwar from appearing on TV despite the serious allegations against him, whereas he made sure that Nawaz Sharif don't lead his party as a president. The reason why Rao Anwar should have been punished is because Malcom X said that we teach you to obey the law, we teach you to carry yourself in a respectable way, but at the same time we teach you that anyone who puts his hand on you, do your best to see that he does not put it on anybody else. When we don't punish people like Rao Anwar, that's why we see Sahiwal incident or many such incidents where law enforcement agencies do extrajudicial killings and go scot-free. Saqib Nisar once raised the book of Constitution and condescendingly said that we disqualified 2 Prime Ministers with this book. Not just politician, but he also humiliated the judges of lower courts. Like on 23 June 2018, Saqib Nisar visited court of Additional District and Session Judge Gul Zamir Solanki with a media coverage and threw his mobile on the table and warned him to put the mobile in the chamber. The irony was Saqib Nisar himself used the mobile in the court. After public humiliation, Judge Gul Zamir Solanki submitted his resignation. Even former Islamabad High Court Judge Justice Shaukat Aziz Siddiqui said that if Saqib Nisar continues to humiliate us, then we will also respond. This humiliation met out by judges is not novel. Maulvi Mushtaq used to humiliate former President and former Prime Minister of Pakistan, Zulfiqar Ali Bhutto, in his court. Saqib Nisar also humiliated Sadiqul Farooq, Hussain Naqi and Ataullah Qasmi, who are senior journalists. He also humiliated Mahmood Bhatti in his hospital and made derogatory remarks against him. See, these judges who are guardians of Constitution and who have taken an oath to protect the dignity of citizens, they themselves humiliate the citizens. Even legal fraternity and puny judges disagreed with Saqib Nisar the way he led the Supreme Court. District and Session Judge Kohat Sultan Tareen filed a complaint in Supreme Judicial Council, and it was the first time in the history that a judge from a lower judiciary is filing a case against a senior judge. Judge Sultan Tareen had written in his complaint that Saqib Nisar took suo motu and contempt of court cases on selective basis. You see, in Bani Gala regularization, Imran Khan submitted fake NOC in Supreme Court, but Saqib Nisar did not question Imran Khan. No one took notice of this complaint against Saqib Nisar, but the complainant, Judge Sultan Tareen, was suspended and later he was made OSD. This is how judges dispense justice. Justice Qazi Faez Isa and Justice Mansoor Ali Shah wrote dissenting notes against Saqib Nisar on the issue of interpretation of Article 184(3), which is regarding suo motu powers. Saqib Nisar's judicial activism choked the executive power, and even Nawaz Sharif on 2nd February 2018 said that courts have quashed the authority of Chief Minister and Prime Minister of forming Judicial Commission. He further said that Prime Minister office has become impotent due to unnecessary judicial activism. There are approximately 2.5 million pending cases in all the courts of Pakistan, but Saqib Nisar's priorities were building dam, controlling population, poking nose in private schools and hospital matters, etc. Saqib Nisar did everything as a Chief Justice except dispensing justice. He himself said that his purpose of life was to build dam and paying back the debt of the country. By the way, 13 billion rupees were spent on the advertisement of dam fund and only 9 billion rupees were collected, while Pakistan need 1450 billion rupees for the construction of Bhasha Dam. This is an intellectual capacity of Saqib Nisar, that he spent more money on advertisement than he collected in a dam fund. And the intellectuals who were saying that it is not possible to collect the colossal amount of 1450 billion rupees through donations, then Saqib Nisar said that I will charge these people under Article 6, which demonstrates his ignorance about the constitution. His demagoguery ultimately made a fool out of himself. He ordered to the telecommunication companies to stop reducing tax on mobile recharge, and after the retirement of Saqib Nisar, Supreme Court reinstated the tax because it caused 100 billion loss to provincial and federal governments. Story doesn't end here. He fixed 1 rupee per litre water tax on mineral water producing companies. Now, maximum tax on water per litre in different countries is 10 to 13 pice, but he fixed it to 1 rupee. In the past, this type of populism demonstrated by Supreme Court has cost the nation heavily. For instance, Iftikhar Ch stopped the privatization of steel mill in 2006 for 22 billion, and now after causing 300 billion losses, it is now being privatized. Similarly, Iftikhar Ch revoked the contract of Rekudik, due to which Pakistan has to pay $6 billion as a penalty. Likewise, in Karke power plant, again Pakistan had to pay millions of dollars penalty, but Turkey has forgiven that penalty. You see, when these judges try to enter in the domain of executive, then they do these type of follies and become a source of huge loss for the country. Politicians and democracy are the best source for the development of the country in every sphere, because it is indispensable for politician to be held accountable of his actions and to absorb all the heat, be it a criticism or a protest by public, whereas judges and dictators are not accountable because they are holy cows. Besides, dictatorships rule you with an iron fist. Musharraf openly said that he doesn't care if his subordinates use drill machine on prisoners.